Welcome to the Smart Legacy Podcast, your resource for protecting assets and securing your future. Hosted by Stockton and Kandt, join us as we cover essential estate planning and elder law topics, such as wills, trusts, and Medicaid planning. Stockton and Kandt, your trusted attorney advisors in safeguarding what matters most. Welcome to another episode of the Smart Legacy Podcast. I'm your host, Glenn Stockton, managing attorney at Stockton and Kandt. We're an estate planning and elder law firm here in the Kansas City area with offices in Overland Park and Gardner, Kansas. In my work with families, I've seen something again and again. The families who plan thoughtfully leave behind more assets. They leave behind clarity, direction, and peace of mind. Because estate planning is not just about passing along valuables. It's also about passing along your values, your priorities, your intentions, and your care for the people you love. This podcast is here to help you make thoughtful, informed decisions so your wishes are honored, your family is protected, and the people you love are guided by clarity rather than chaos. Today, we're going to talk about the topic about why most estate plans still fail. So I'm glad you're here with us. Let's get into it. So why do most estate plans still fail? People, they go to the attorney, they get their estate plan done, their will, their trust, their powers of attorneys, and they get everything in order. The plan's done, they feel good, they have that peace of mind that they've done good estate planning. And they take that estate plan, the will, the trust, whatever it is, they take those documents as they were told to by their attorney, and they go put them in a place of safekeeping. They put them in the lockbox or a safe at home or some folder. And for most people, there they sit. Nobody looks at them. Nobody updates them. They just sit there until something happens, and now those documents are needed. And the family, comes out. So I'll give you a scenario where, mom and dad have done some estate planning, they've done a will, they've got their powers of attorneys, they feel like things are in order, but that was done years ago, right? And it's been in this place of safekeeping. And then mom has a stroke. She has to go to the hospital. The family, they can't remember exactly where the documents are at, but they find them. They were in a folder in the file cabinet. They get them out. They had to go back to the house to get it because nobody thought to get them before they went up to the hospital, but the hospital was asking for them. So they go back and they get the health directives and they give to the hospital. And at points, people make decisions as long as nothing's changed there. Those work pretty well, right? See it all the time because on the healthcare documents, those don't change all that quickly or all that often. The people you appoint still are people you might or probably want to have involved 5 years later, 10 years later. So things are working fine. Then husband's got some things he needs to deal with, her IRAs or talk with Social Security. And he pulls out that financial power of attorney. And the bank says, I'm sorry, it's too dated, it's too old, we're not going to honor it. She dies. The will governed, but they had beneficiary designations, they thought. They had the will governed. They had a trust. Maybe they had some things in the trust, and they find that they ended up having to go to probate. Why? Because their assets had changed since they had done this plan. They were no longer the same assets. They weren't titled properly. Beneficiary designations weren't set up correctly. And now husband's finding himself having to go to probate court while she's alive for the guardian or for the conservatorship, and then at death for probate at death. And it happened because we treated the estate plan as if it was a transaction, as if estate planning is all about the documents. And I've talked about this before, guys. I see this all the time. It is how most people approach estate planning, including most attorneys. Most attorneys do exactly as I said there. They help you prepare the documents and they tell you, put it in a place of safekeeping and come see me if things change. They don't have any type of system to help you review that, help you keep it up to date. And so those estate plans, the vast majority of estate plans, are designed to work when they're signed, but they're not necessarily designed to work when you need them. So what I encourage people is think of estate planning not as a transaction. It's not just about the documents. Most estate plans fail because that's how they're treated. Once we get the documents, we think we're done. So we encourage people to think of estate planning not, is all about being about the documents. Those documents are one leg of a four-legged stool. They're highly important, but we need to review them periodically. I encourage people, let's review them on an annual basis, the once a year annual review, right? And those documents represent one leg of a four-legged stool. And every year when we come in for the annual review, we're going to review that leg, right? We're going to review the documents. Here's who you named to be your executor. Here's who you named as your trustee. Here's who you named to make financial decisions if you can't do so. Here's who you named to make healthcare decisions. Here's who you've named as your beneficiaries. It's that type of thing. Is this still the way you want it? Is this still who you would choose? How's your relationship with them? How does everybody get along? Is there anybody else that should be included here? We look at it. I like the once a year, just create a cadence of once a year. We come in, we put our eyes on this stuff, but at least every few years. And when we do that and we keep that up to date and the documents, we've got the right people, that's part of it. We need to make sure that we have a plan for long-term care. What happens if we need to go into nursing care, assisted living? How are we going to pay for that? Is our plan going to work? And there's various ways we can do that. We can insure the risk, right? Where we can go buy long-term care insurance or some sort of insurance product that we are insuring the risk. If we ever need long-term care, we have insurance to help pay that cost. Maybe that's part of your plan. Maybe the plan is we're going to pay for it out of pocket, but not all assets are treated equal. So which assets are we going to use? Maybe we need to make some adjustments there. Maybe our plan is we've designed a trust to be able to help protect things. Are things titled properly in the trust? We need to review that plan on a regular basis to make sure no adjustments need to be made. Because if you need to go into care, those plans are what's going to help us make sure that you're protected. That's leg 2 of the stool. Leg 3 is taxes. Plan for taxes. Leg 4, and this is the important one, why plans fail. Often it's because there's no alignment between the assets in the plan. Somebody's created a trust, but if we never get the assets into the trust has no control over those assets. It's not going to work. We have to fund the trust. And if we're not going to use a trust, do we have proper beneficiary designations set up on them? And are those beneficiaries up to date? Are they still the people we want? Do we have beneficiary designations on each asset? Because again, if we don't, then the courts are going to get involved. We're going to go through probate. And probate it's expensive, it's time consuming, and it's a burden. And the number one thing we hear as to why people want to get their estate plan done, number one thing we hear is, I don't want to be a burden. Yet if you don't do the planning, you're going to be a burden. We've blown it. And if you treat your estate plan as if it was all about the documents, you got them drafted, you signed them, you're done, and you never look at them again, you're going to be a burden. It's not going to work like you think it's going to work in all likelihood because things change. So you want to review those documents periodically. I like that once a year. Again, it's an hour a year. That's why I tell clients, give me an hour of your year. We don't charge that me, right? So for our clients, our process is I want to see my clients on an annual basis. Come in, we're going to go through the annual review. We're going to review those plan choices, confirm all the names. Do we have everybody in the right position? Are your beneficiaries the way you want it? Guys, that doesn't take very long. And that doesn't change every single year. It may never change, but for most people, there's some changes. Maybe we did the plan when the kids were young and they weren't ready to handle the responsibilities yet. Now they are. We've named people who are no longer, in our lives or able to, fulfill that role, or just not the people we would choose anymore. So these things can change, and so we update the documents. But you want to review it every year to make sure no updates are necessary. It doesn't take long. Make sure you're reviewing the assets. If you only did 2 of the 4 legs, those would be it, right? Review your plan choices and make sure that there's alignment. And so by alignment, what I mean is you're looking at account titling, the ownership of those accounts. Are they titled like they're supposed to be with the plan that you have in place? And are beneficiaries set up the way that coordinates with your plan? There needs to be a coordination. And for most people, that coordination is lacking. There is no coordination. The financial planner and the attorney never talk to one another. The attorney gave some directions. Here's what to do with the assets. Clients meant to go do it. They were going to take it to their financial advisor, but they were busy. They put the will aside. Some weeks go by. They forgot that they were supposed to make some changes. It's in the documents. It's written in there in their plan, but they haven't pulled it out to look at it. They forgot it, never got done. The financial advisor doesn't even know there's a plan, or the advisor does know, he or she doesn't know, how it's supposed to be titled. So they're just setting up accounts based on answers you're given, and you've forgotten how you set up as well. We see this all of the time, and there's no alignment. And all of a sudden, those assets don't go according to the plan. So you want to make sure that when you're reviewing, you review those documents, review your plan choices, but then go through each of the assets. We use an Excel spreadsheet. We call it the asset detail report, right? Just an Excel spreadsheet. And on that spreadsheet, I'm able to put in, here's all the cash accounts, right? The bank accounts, checking, savings, money market, CDs, whatever those cash accounts at, bank money. What type of account is it? What bank is it at? How's it titled? And how's it supposed to be titled? Who's the beneficiaries? If we have a trust, is it titled in the trust? If we're not going to use a trust, we're going to use beneficiary designations, do we have the pay on death beneficiary designated on that account? Have we opened up new accounts? Have we closed up accounts? If we close them, get them off there. It's no longer relevant. It just confuses things for those we leave behind. So we update the bank accounts every year. And I just ask my clients, provide me with an account statement. When I see an account statement, right, I can look at that asset. I know how it's titled from that account statement. I know how it is taxed from that account statement because I know what the asset is. I can see that in there. I may not know who the beneficiary is, but if we're using a trust-based plan, and as many of you know, I'm a big proponent of trust. I think trusts are fantastic estate planning vehicles. They are the preferred choice when we do an estate plan. Does that mean everybody needs a trust? No, of course not. But what I tell clients is don't overcomplicate this. If the things that a trust can do for you are important to you, then we need to look to the trust. If not, well, then maybe let's use a will with some, strong, powers of attorneys and, other living documents, and then couple those with beneficiary designations. But if you have a trust and the assets are titled in the name of the trust, I'm going to see that from the statement. And if they're in the trust, then I know who the beneficiaries are because the trust is going to control that. As I said, trusts are powerful, not only probate avoidance vehicles, but they're powerful disability incapacity planning instruments that keep the courts out of your affairs, make things easy, make sure that the people that you've appointed are the ones making the decisions or carrying out the decisions you've already made. You're giving them the guidance. And so we also want to make sure we're updated. We've got all the bank accounts listed. And so if you've got an account up there that you closed, just remove it off there. It's relevant. It's going to create confusion for those people that you've appointed to come in and manage your affairs when you can't. If you open up a new account, make sure it's listed, right? That's easy. So you got your bank accounts. Then we like to move on to our non-qualified or non-retirement investment accounts. The Edward Jones account, the Waddell, I guess Waddell and Reed's not around anymore, but the Morgan Stanley accounts, the Charles Schwab's, the investment accounts, not the IRAs, not the 401ks, retirement plans, non-qualified investment accounts, individual shares of stock listed on there. right? Approximate value. How's it currently titled? Or how should it be titled, right? Make sure that it's in alignment. Here's the recommendation. Is it where it's supposed to be? Look at it every year. Then we go into the qualified money, the IRAs, the 401ks, the 403bs. Same thing. Is this all titled the way it's supposed to? Are beneficiaries set up correctly? Is this account still exist? Update the balances. Do that each year. Life insurance, real estate. You go through your classes of assets. So we just use an Excel spreadsheet to help guide us through that, to make this easy, and make sure that your plan works when the time comes that you're going to need it. You also want to make sure that you create transparency, because here's another reason plans often fail. Let's assume we did everything I just said. We put the plan together. We've treated it, correctly, where we're reviewing it on an annual basis. We're making sure that everything's up to date. We've kept the list of the assets, where they can be found, but we never tell anybody about the plan. They don't know we have an estate plan. We don't know we have the trust. They don't know where the documents are at. And then you die. Where's this stuff at? How does anybody know what to do? If they don't know the trust exists, they don't know where to find that trust, how are they going to carry out the wishes of that? And so those plans often fail because there was no transparency. Nobody knew about the plan. They didn't know what to do. And so even if we eventually get there, it's typically been difficult. We've had to maybe get attorneys involved, costs involved, sometimes courts involved, because people didn't know that there was a plan in place. And so if the purpose of our plan was not to be a burden, well, we failed. That plan has failed at that part because we didn't create transparency. So we want to make sure we review our plan choices every year. We want to make sure we look at the assets, that there's alignment between how things are titled and how beneficiaries are set up, that those are in alignment with the plan. And then we want to make sure that we have told the people who need to know about the plan, what they need to know about the plan, where they're going to find things when the time comes. We like to do that through what we call the family meeting. So, this is how we do it in our firm, right? When we get hired, we do everything on a flat fee basis. We're hired. Part of that flat fee includes we offer to meet with our clients on an annual basis. It's just, we don't charge for those meetings. There's no fee for us to meet. We're happy to meet with people each year and just review their plan with them at no cost. And we're going to confirm those plan choices. As I walked through earlier, here's who you name to make financial decisions. Here's who you name to make healthcare decisions. Here's who you named as your beneficiaries. That type of thing. We're just reviewing that with them. Is it still the way you want it? That annual review, we're looking at the assets. Is everything titled properly? But in the other meeting we like to have that we offer at no charge to our clients is what we call the family meeting. All right. We want your loved ones to know. So let's assume it's kids, right? Because for most people, they're the ones we're leaving stuff to, and they're even the ones who are making decisions if we can't. So if mom and dad have a plan, an estate plan, I want the kids to know that mom and dad have a plan. So the purpose of that family meeting is to say, hey, mom and dad have a plan. Here's what you need to know about the plan. Here's where you're going to find things when the time comes. Here's what your roles are. Here's things you need to know about this. We're creating transparency. We put together for our clients what we call the 911 checklist, what to do at incapacity, what to do at death. Remember, we're trying to create clarity rather than confusion. So we put the checklist together, what to do at incapacity or death. Here's what needs to be done, immediately. Here's when the tax returns due, so we just kind of map things out of what needs to be done, when it needs to be done. And I review that with the kids or with the family that's in present. We review what their role is. We make sure they know with our client, what's the plan of death? Do we want to be cremated? Do we want to be buried? Because if you don't make those decisions, somebody else has got to make those for you. And there may be disagreement on that because you didn't make it clear. So they thought you wanted one thing and you wanted something else, and other kids, no, mom told me this. So in that meeting, we try to make sure that we've been clear as to what happens at death. What level of care we want with the feeding tubes, and do we want to be on feeding tubes if there's no chance of recovery? Do we want it to be on the ventilator? Those type. We're having those kind of discussions so that we're creating clarity. And I tell the kids, you don't have to remember this. Right? You don't have to remember all this. We've got this in the checklist. We use a red estate planning binder, so our line is red binder, red tab. That's all you kids have to remember. We've got this mapped out for you. But when we do the family meeting, part of that is they know about us. So they know to reach out for us. If they can't find a copy of it, guess what? We've got a copy. Reach out to us. We have copies of that. And we're going to walk the kids through what the roles are, and we want them to know where we're at. And so we're creating that clarity. So we encourage you to do the family meeting. Review your assets on a regular basis. We're going to increase the likelihood that your plan is going to work when we need it to work. So don't treat it as a transaction. Another reason plans often fail is people aren't considering what happens if they ever need to go into nursing care, long-term care. Right? There was no plan. We didn't plan in advance for how to deal with that. And the plans fail because we go broke paying for care. Mom and dad are, they've had this plan, an estate plan done. They had their will, they had their powers of attorneys, they had their beneficiaries done. They were reviewing it on a regular basis. They had the family meeting. Assume they did all that. But they never planned for what happens if they needed nursing care. Most people don't. As I like to say, most people, when do they do that planning? When they're seated at the admissions desk at the nursing home. Then they're like, oh my gosh, this is going to be expensive. How are we going to deal with it? See it all the time. It's how when people come to us, then they seek out our services as elder law attorneys, and there's a lot we can do to help them. But guys, it is so much more expensive, so much more of a burden than had we simply done the planning early. So when we do an estate plan, we want to make sure we're addressing what happens if we need long-term care. If we plan early, it's not complicated. It's not overly expensive. In fact, it doesn't necessarily have to cost anything extra. We're just making sure we have a plan in place. And part of that review process, that was leg 2 of the 4-leg stool. We just want to review and make sure that plan still works. But when we don't have plans made and somebody's got to go in care. So I started to go down that scenario where I've got this husband and wife, and husband needs to go into nursing care, dementia, Alzheimer's, whatever it is. He goes into long-term care, but there's no plan for it at that point. Now we have all the expenses of the home. Wife's still at home. She's got all her expenses. But now on top of that, now we have the expenses at the assisted living community or at the nursing home, and it can be expensive. And now we're having to spend through money to pay for that. And now there's very little money, if anything, left for wife, if she ever needs care or to get her through the rest of her life. And there's very little to pass on to kids. And so the plans fail because we failed to plan for that potential scenario where we might need care. We want to make sure that everybody has a plan. Why? Well, statistically, 70% of us, more than 2/3 of us, are going to need long-term care at some point in our lives. We need to make sure we're prepared for it. It doesn't have to be difficult. Plan early. Make sure your estate plan addresses it. Another reason that plans fail, they didn't update their powers of attorneys. They signed the power of attorney. They've reviewed it. Yep, still says what we want, but they never re-signed it. They never updated it. In today's world, most financial institutions have a 5-year rule, meaning they will not honor a power of attorney that is more than 5 years old. All right? Let's think about this. Why would that be? Well, they're worried about getting sued, right, of being questioned. Somebody walks into the bank with a power of attorney and says, hey, I've been appointed under this power of attorney to be in charge of this account. And they walk in the bank and they say, I want to close out the account. Give me the $3 million in this account. Give it to me. It's my money. I'm using my power of attorney. And that power of attorney was signed 30 years ago. Good luck, right? The bank's not going to honor that. They're concerned, like, how do I know you have the authority to do this? Most banks and financial institutions say if it's more than 5 years old, we're not going to honor it. Some of them have 1-year rules. They're not going to honor it if it's more than 1 year old. So plans fail because we don't keep it up to date. Our process, when clients come in for the annual review, I just have them re-sign their power of attorney. I don't need to charge for that. Why? Well, because, literally all we're doing is we're printing the signature page, right? We're reprinting it with a new date on it. We want fresh ink on the signature line, and we want a fresh notary stamp. Right? Even if we're not going to change who's making the decisions, who we're appointing, we just want to keep it up to date. And I also recommend to clients, take your financial power of attorney, take it to your bank, take it to your financial advisor, make sure they have a copy of it. Is there anything they need, they want you to sign, or additional information they want to make sure that the people you choose have authority to make decisions when the time comes? So they fail to keep their power of attorney up to date. They failed to do any tax planning. Right? So their plans failed. Their plan was they wanted all those assets to go to the kids or to their spouse, but they gave no consideration to the tax impacts. So this is especially true when we're dealing with things like the IRAs, right? The IRAs, the 401ks, 403bs, those retirement accounts. A traditional retirement account or traditional IRA or 401k, that money's never been taxed. It was tax deferred. We put the money into the account and deducted it from our income, saying, hey, we're not claiming this as income. We're not going to pay taxes on this yet. But what happens at age 73, right? It's under current law. If you're born 1960 or after, you will not be required to take your required minimum distributions until 75. Anybody born before 1960, their required minimum distributions start at age 73. So you turn age 73, you are required to take a distribution out of your retirement account. Right? And the IRS tells us how much we must take. And every year that amount goes up and up and up. And nobody's thinking about this. Nobody's planning in advance. So husband and wife, they had these IRAs. They're taking the distributions. And then one of the spouses dies. So we'll stick, as I normally do, picking on the guys. Husband dies. Because statistically, you gals are more likely to outlive your husbands. So husband dies. Who was the beneficiary of his IRA? Wife. So he was taking distributions out of it. His wife was taking distributions from hers, right? They were filing jointly tax return. And every year the amount of income, the amount they were forced to take out of those retirement accounts was going up and up and up, and it was pushing their income up, and it was pushing them into higher tax brackets. Now husband's died, wife is the beneficiary. She has to take the RMDs from her IRAs, her retirement accounts. Now she also has to take the RMDs from her husband's IRAs, the ones she inherited from him. She's having to take roughly the same amount of required minimum distributions as she had to take when there was both of them, when her husband was still alive. But now, instead of being a joint tax filer, she's taking these distributions and she's a single tax filer. And when we take distributions out of these accounts, whether it's because we were required to as part of our RMD or because we just wanted to, we voluntarily took more out or took it before we were required to, whatever the case is, every dollar that comes out is income to us in the year we took it out. So wife's being forced to take out from hers and husband's, and it's all income to her. But she's now a single tax filer. She's no longer eligible to file a married filing jointly tax return. She's filing a single person tax return. And single people pay more in taxes than married couples. She lost half of her deductions. She also went from a married filing joint tax table to a single filer tax table, meaning her brackets got cut in half. So she's moving into higher incomes at half the income level as before, but yet her income hasn't changed that much because she has her RMDs, and she's got husband's RMDs. She lost the smaller of the two Social Security checks, but other than that, income tends to stay pretty much the same. And it's forcing her into higher tax brackets. So the government's taking more and more every single year. And then when she dies, and now it's going to the kids have 10 years to get that money out and pay taxes on it. So they've got to take it out in bigger chunks. They're forced to take it out. And every dollar that comes out is income to them. And those kids, they may be in their prime earning years. And it's pushing them up into higher tax brackets. So Uncle Sam has taken a bigger piece of the retirement plan. And so the plan's money is not gone in accordance with the plan, right? Because Uncle Sam and Aunt Iris, the IRS, stepped in, and they're taking now between state and federal taxes, a third or more of the money, right, that was intended to go to the kids or grandkids, whoever it was. And it was because we failed to think about it. We failed to plan around taxes. We failed to do anything about it. Most people do not have a plan of how to deal with taxes. They just file their tax return every year. When RMDs come, they take the RMDs. There's no tax plan goes on. So that's another area that we see plans fail. So the big takeaway, I think, today is to, make sure that you're reviewing your plan periodically. Don't think this is just one and done. I did the plan. I put it in a place to safekeeping, and I don't have to do anything more with it, right? Treating it as a transaction. That's how most of the world treats it. But I would encourage you to think about it differently. Review the documents. Update your power of attorney. Make sure there's alignment in the assets. Make sure you have a plan for taxes and long-term care. And do that at least every few years. You're going to look at this stuff. But if you do this on an annual basis, it does not have to be overly complicated. It's not overly expensive. As I said, within our firm, we do those annual meetings at no charge for our clients. We're going to help walk them through this. So if you're not working with an attorney that helps you do it, well, maybe you need to start thinking about working with an attorney that can help you do this. And we would be honored to sit down and talk to you about what it looks like if we're helping you with this. But even if you're doing this on your own, the stuff is important. Pull it out. Make sure you're looking at it. All right, so as we wrap up today, I want you to remember, estate planning is not just about paperwork. It's about protecting the people you love and making life easier for them when it matters most. Thoughtful planning today can spare your family confusion, conflict, and unnecessary burden tomorrow. Your estate plan, or lack of one, will one day speak for you when you no longer can. And it's going to help determine whether the people you love are protected or burdened, whether grief is softened by clarity or made harder by chaos and confusion. And what is left undone today often becomes what families must deal with later. And when the time comes, you die. There's no opportunity to go back and fix it. You don't get second chances. When we do estate planning, I remind people of this because I don't think people give it the attention to which it deserves. When we're putting an estate plan together, we are planning for a very specific time in everyone's life. Very specific day. Right? That's the time of death. We do that planning not in fear of death, but we do the planning in respect of the certainty of death, with respect to the power of death. You know, as I've said a couple times here, what is left undone when you die remains undone. You have no opportunity to go back and fix it. You're leaving it for others to have to do. And we've left them with chaos and confusion and burden because we didn't create clarity. So this is not a transaction where you get the will done, the trust done, stick it in a drawer, and forget about it. Not if we want this to work well. Get your plan done, review it periodically. All right, if today's conversation gave you something to think about it, I think that's a good thing. These are important conversations to have, and I think they're worth sharing. So thank you for spending time with us on the Smart Legacy Podcast. If you found this episode helpful, please subscribe, share it with someone you care about. These topics matter, and sharing them helps more families plan well. You can find us on YouTube, Apple Podcasts, Spotify. You can also visit us at stocktonlaw.com, where you'll find all of our episodes and many other helpful resources. So until next time, plan thoughtfully, take care of the people you love.
The information provided in this podcast is for general informational purposes only and does not constitute legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, and this podcast focuses on estate planning and elder law in Kansas and Missouri. If you are located in Kansas or Missouri and require legal advice, please contact our office. Otherwise, consult a qualified attorney licensed in your jurisdiction.